Shut up about politics. Ain't nothing but a big pile of dirty tricks. I'm tired of all the fighting and a pitching fits, so shut up about politics.
All right, welcome back, folks. In a set of 2 lectures, we're going to take a look at the political question doctrine and separation of powers. These are 2 different things, but in these lectures, we're going to see instances in Supreme Court history where they've come together. So the political question doctrine basically states that there are some issues that are not for the judicial branch to decide. They are instead for the 2 political branches, the executive and the legislative, to decide. So for instance, if a question was intended by the framers to be committed to the process of ambition counteracting ambition, then the court will beg off of that question and leave it to the other 2 to fight it out. However, we've already seen that in the 20th century, the court got a lot more aggressive in asserting its powers of judicial review to claim the power to review almost everything. And part of that was determined within the incorporation debate, which we took a look at, when the court came to say that more and more state laws were subject to review because the 14th Amendment due process clause gave the court the power to protect individual rights against state intervention. And we've seen that James Madison was very concerned with state violation of individual rights, but he wanted the national legislature to act to protect these rights via the negative on state laws, and he wanted the judiciary to be involved in this as part of the Council of Revision, but only before laws were made. He eventually came to accept a Bill of Rights because it might empower courts to do some of the protection of rights that he envisioned via the negative and Council of Revision, but he never envisioned that the Bill of Rights would apply to the states. Okay, to see how the court initially sort of stayed out of political questions, we have to see how it initially stayed out of all questions involving the powers of the states, as the framers thought it should, something else we learned in our lectures. And then from there, we're going to proceed, and we're going to see how once it started to get involved in state questions, the court decided it could also take a much more aggressive stance regarding the separation of powers in the federal government as well, and that it could step in where previous courts had let the political branches duke it out, oftentimes via ambition counteracting ambition. So the political question doctrine was first discussed in a case called Luther versus Borden in 1849. Facts of the case? In the 1840s, Rhode Island experienced a widespread rebellion against its elected government. Middle-class craftsmen and tradesmen in particular thought that the government was controlled by a landed, rural, essentially aristocratic elite, so they took up arms against it. Martin Luther was part of this movement, which came to be called the Dorr Rebellion, which sought to broaden the voting rights extended to state residents. Now, Mr. Luther was arrested by Mr. Borden, a state official, and that brings us to our legal issue. Luther contended that the state government was not Republican in nature because it restricted the electorate to only the most propertied classes. We saw that word Republican emerge in our readings of James Madison. And Article 4 of the Constitution states that, quote, "The United States shall guarantee to every state in this union a republican form of government." Now, Mr. Luther argued that since Rhode Island's government was aristocratic or oligarchical, it did not have republican authority, and therefore Mr. Borden had no authority to arrest him. If they had agreed, the court would have necessarily found that the alternative Republican government, which had been set up by the Dorr rebels, was in fact the lawful government of Rhode Island, indeed, because it was Republican in nature. But what the Supreme Court did was essentially punt. And this gets us to the rule that they articulated and the finding in the case. They said it was up to the President and Congress to enforce the so-called Republican guarantee in the Constitution. And they said that as an inherently political question, that was outside of the purview of the court to decide. So they say this on page 39 of the decision. They're talking about how the state courts would act, making an analogy to how they should act. They say, in forming the constitutions of the different states after the Declaration of Independence, and in the various changes and alterations which have been made since, the political department has always determined whether the proposed constitution or amendment was ratified or not by the people of the state, and the judicial power has followed its decision. So, if the state courts would take a state constitution or amendment as legitimate, if the legislature and executive told them it was legitimate, then that at least suggests that federal courts should do the same. Regarding the federal court's limitation to act, they then make this argument on page 42. They basically say, well, look, if the Constitution gives authority to act to one of the political branches, then that decision is essentially non-justiciable. So, for instance, the veto power gives the president the authority to veto without any standards that she has to follow in so doing. It gives nothing but a procedure. It's up to her. It's a political question. Although Article 4 does express a standard of sorts, it said that governments must be Republican, the court basically said no. The Constitution as a whole also expresses a procedure to follow when there are disputes like the ones in Mr. Luther's case. They make this argument on page 42. Article 4 guarantees a Republican government and guarantees the states against, quote, domestic insurrections, but it does so with this explicit procedure in the Constitution. On the application of the legislature or of the executive, parentheses, when the legislature cannot be convened, against domestic violence. Okay? But you might be asking, application to whom? To whom would the state make this application? Which branch of the federal government is the state supposed to apply to in order to invoke the protections for its Republican form of government? Well, the court, in this case, said this, quote, under this article of the Constitution, it rests with Congress to decide that government is the established one in a state, because when the senators and representatives of a state are admitted into the councils of the Union, or in other words, when the elected people from those states are admitted into those bodies, Senate and House, there's a procedure for that in the Constitution. They go on, the authority of the government under which they are appointed, as well as its Republican character, is recognized by the proper constitutional authority. But note something here. This does come from a clause in the Constitution giving Congress this authority. The court here, however, reached to another part of the Constitution for a justification of what they were deciding about the Republican guarantee. So they stitched together two different parts of the Constitution to say Congress must be one of the authorities, at the very least, allowed to hear an application from the states for the Republican guarantee. And then they added something else. They said that Rhode Island had applied to the president for military help, and although the state had been denied in the midst of the Dorr Rebellion, the president at least considered the application, therefore recognizing that the previous government, the one that did the application, was the legitimate application. Now, this also comes from the Constitution, the president's Article 2 power to command, quote, the militia of the several states, when called into the actual service of the United States, was the basis on which Rhode Island appealed to the president. But notice that the Constitution didn't explicitly state either of these procedures for the Republican Guarantee Clause. It does not say that the decision to seat legislatures shall decide the issue of whether a government is Republican, or that the president's authority to call up an army will decide this issue. So the court essentially punted in this case. It decided based on other provisions of the Constitution that the framers must have had a different political procedure in mind for guaranteeing Republican governments. But in the 20th century, the court became more aggressive in deciding when it could wade into matters that the Constitution had seemingly committed to other branches. They started to decide that there really had to be an express provision of the Constitution committing that decision to one of the other branches, or to both of them in conjunction with each other. And not surprisingly, they did this in their application of the 14th Amendment to the states. In other words, the incorporation debate, which we already learned about. So as you listen to our next case, compare the way in which, in Luther versus Borden, they had sought out justifications to not get involved in that case, to declare it a political question. And in this next case that we're going to hear about, unless they are explicitly told with a no trespassing sign to stay out of the question, they're going to get into it. Baker versus Carr in 1962 was a case about redistricting in Tennessee. And as usual, I'm going to give it to you the way a law student would in what's called a brief. I'm going to start with the facts of the case. I'm then going to move on to the law or legal issue presented, and then I'm going to move on to the rule that was articulated by the court in order to reach its holding or decision. It's going to be super brief, so I'm going to use this graphic to help you follow along. Facts. Mr. Baker was a Republican, and he complained that in his race for mayor of a town, rural voters were greatly overrepresented compared to the population as a whole. Tennessee hadn't redistricted since 1901, and since Baker had to win a number of districts in order to win the mayorship, not just the popular vote, but he had to win districts, he claimed that the overrepresentation violated something, right? It violated the Tennessee Constitution or the principle of democratic voting or something. So the law, the issue. The court never actually decided what principles were violated in the case because they only decided whether this was an inherently political question, whether it was given to the state legislatures to decide voting rules entirely by themselves, or whether the Due Process Clause of the 14th Amendment had granted courts some power to intervene, in particular perhaps the Supreme Court, but lower courts as well. So the rule, or the holding in the case, well, they decided, the Supreme Court did, that that court, or courts in general, did have the power to intervene, but they simply sent the case back to Tennessee courts to decide according to the Tennessee Constitution. It wasn't until 2 years later in Reynolds versus Sims that the court expressed that the U.S. Constitution actually relied upon a fundamental justiciable principle of one person, one vote. So Baker versus Carr wasn't decided because some people's votes counted for more than other people's votes. It was decided solely on the issue of when courts can intervene or when they must stay out of political questions. So we're going to take a look at the various different rules that they established in Baker versus Carr for this political question doctrine, as we're going to call it. So take a look at this graphic that articulates 6 rules that come on page 217 of the decision. And they said courts should stay out of any legal issues where there is, first, a textually demonstrable constitutional commitment of the issue to a coordinate political department, or in other words, when there really is a political question at stake. 2, a lack of judicially discoverable and manageable standards for resolving the case, or in other words, does the constitutional provision that is at issue, that is the governing law, actually state some sort of rule that the court could then apply? 3, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. So if they had to get involved in policy, they would stay out. The impossibility of a court's undertaking independent resolution without expressing lack of respect due to the coordinate branches of government. An unusual need for unquestioning adherence to a political decision already made. Or the last, number 6, the potentiality of embarrassment from multifarious pronouncements by various departments on one question. Now, all of these mean something in particular, and all of them are relevant to certain Supreme Court cases, but we're going to focus on the first 2, a textually demonstrable constitutional commitment of the issue to another branch, creates a political question, and the court should stay out, and a lack of a justiciable standard means the court should stay out. The first says, when the Constitution states a procedure according to which the other branches are supposed to decide something, stay out. But the second actually becomes the pretext for the court claiming a lot more power over the course of time. The second said that when there is some sort of principle or standard that those branches are supposed to follow, for instance, to make a decision consistent with the public good or the general welfare, when there is such a standard, then courts can intervene. And what we'll see in our second lecture is that this created the Supreme Court's opening for doing a lot more.